Imagine this: the Secretary General of NATO, one of the most powerful positions in the world, being dragged into court by a lone Dutch whistleblower. It sounds like a political thriller, doesn't it? But it isn't fiction, it's real. This is unfolding now, and especially today, February 3rd, 2025. This is the story of Karim Aachboun, a American-Dutch tax advisor of all professions, taking on Mark Rutte, former Dutch Prime Minister and now head of NATO. This case isn't just about one man's fight for justice, it's about exposing power, shattering immunity and forcing accountability. Why should you care? Because this isn't just about the Netherlands or NATO. And this is way bigger than Aachboun or the Netherlands. If successful, it could shake an entire global order, and this is no clickbait or exaggeration. For way too long, those in power, whether they lead nations or international organizations, have been virtually untouchable. But this very case could change everything. It could prove once and for all that no leader, no matter how high, is above the law. At the center of it all, two interconnected scandals. First, the Dutch childcare benefits scandal, a national disgrace that devastated thousands of families, most of them immigrants. Second, and this is where we are focusing on today, the Gaza conflict, where Dutch military support contributed to the death of many civilians, including, and again essential for this case today, a Dutch woman of Palestinian descent. Karim Aachboun's fight isn't just legal, it's moral. He's demanding accountability for destruction at home and abroad. But it's NATO's immunity that makes this case so extraordinary. That immunity, meant to protect organizations, has instead become a shield against justice. What happens when that shield is used not for defense, but for evasion? If Aachboun succeeds, if NATO's legal immunity is broken, it will send shockwaves through the world's most powerful institutions. It would force a complete re-evaluation. Can justice truly reach the highest echelons of power? For decades, politicians and bureaucrats have operated under the assumption that power comes with impunity. But what if this assumption is crumbling? If Aachboun wins, the message would be clear: accountability is not optional. No title, no organization, no immunity can protect the powerful from justice. And the most important point, this case could redefine international law. If NATO's immunity is pierced, then what stops the United Nations, the European Union, the IMF or the World Bank from facing similar challenges? This case could open the door for victims of systematic injustice to finally demand justice against those who once seemed untouchable. So again, this isn't just about Aachboun, this isn't just about Rutte, or this isn't even just about NATO. This is about us. Do we as a world community accept a world where power is absolute? Or do we demand a world where justice knows no borders? So stay with us, today we break it all down. To truly grasp the gravity of this case, we must talk about Gaza. The Dutch childcare benefits scandal is heartbreaking and a national shame. But it remains a domestic issue. Aachboun's case against Rutte, however, is a global one. It's a story of war, human suffering, profit and complicity, but far beyond the Netherlands. If you live in the West, you may not believe it, but the war on Gaza has divided the world. For years, Palestine has been a battlefield where military force meets humanitarian crisis, with virtually tens of thousands of civilians trapped in the crossfire. And here's exactly where the Netherlands come in. Under the then Prime Minister Mark Rutte, the Dutch government authorized the export of military components, including critical parts for the F-35 fighter jets, to Israel. As we all know, these jets were not only used in airstrikes that devastated Gaza and reduced whole neighborhoods to rubble, but these airstrikes killed virtually tens of thousands of unarmed civilians. One such strike, and that's really important for our case today, killed a Dutch woman of Palestinian descent, which was an act that underscores the very real human costs of these policies. This isn't just about one tragic death, although of course her family's pain cannot be ignored. This is about complicity, about a nation playing a role, however indirect, in the destruction and loss of innocent lives. And yet, no one has been held accountable. No government official ever has faced consequences for policies that contributed to this very devastation. That's what makes Aachboun's case so powerful. He's saying enough. He's demanding Rutte, and by extension NATO, to answer for their actions. Because, and let's be clear, when leaders and institutions operate with impunity, victims of their decisions are left without justice. And that's not just a failure of the courts, it's a failure of our collective humanity. This is exactly where NATO comes into play. Rutte is not just a former Prime Minister. He now leads NATO, an institution that enjoys near total legal immunity. That immunity was originally meant to protect operations. But what happens when it becomes a tool for evasion? What happens when it shields individuals rather than principles? Should Aachboun's case succeed, it would send shockwaves through international organizations. It would fundamentally challenge the way powerful institutions balance immunity with accountability. Let's be very clear, this case has the potential to become a true watershed moment. Now let's have a quick look at Aachboun's legal battle. In July 2024, Karim Aachboun took a bold step. He filed an urgent petition in the Dutch-speaking Court of First Instance in Brussels. His demand? Block Mark Rutte's appointment as NATO's Secretary General. His argument was both clear and groundbreaking. He argued that Rutte's actions at home and abroad had inflicted immeasurable harm. Allowing him to assume his new position at the head of NATO would shield him completely from any accountability. So Aachboun's case stood on two pillars. First, the domestic, the childcare benefit scandal, a disaster that shattered lives, exposing systematic injustice in the Netherlands. Second, the international, the Gaza conflict, where Rutte's government facilitated military support that contributed to mass civilian casualties. Together, these scandals painted a damning picture of a leader who, in Aachboun's view, failed those he was sworn to serve. The hearing began in August 2024. Aachboun's legal team argued that Rutte's NATO role would grant him blanket immunity from lawsuits linked to his tenure as Prime Minister. But this case was more than just a legal battle. It was a moral plea, a demand to redefine power and accountability. Not surprisingly, the court's initial ruling, delivered on October 2nd, was a major blow. Now get this, the court deemed the case admissible but unfounded, and it was citing NATO's immunity and jurisdictional limits. That's a technicality, but one that illustrates the near impossible challenges of holding powerful institutions accountable. For many, this ruling would have been the end, but not for Karim Aachboun. Refusing to surrender, he immediately filed an appeal. By January 2025, the case reached the Court of Appeal in Brussels. This time, Aachboun's legal team pushed an even stronger argument: that immunity must never shield for injustice. Then came a revelation. As the appeal hearing unfolded, a letter from NATO surfaced not just to the judge, but to all ranks and files of the court. NATO was arguing it should not be a party in the case. Critics called it an open attempt to pressure the judiciary, a brazen move that only fueled Aachboun's fight. It gets even better. NATO's legal team then tried to erase the letter from the case file. But the judge, in a rare moment of defiance, ruled against them. The letter would stay, a clear sign that even NATO must face scrutiny. And now a moment of truth. One of many. Today, February 3rd, 2025, we are awaiting the ruling. Whatever the outcome, one thing is certain. Karim Aachboun's battle is not just legal. It's a fight for the soul of justice itself. And just when you think this case couldn't get any more explosive, it does. In a move that stunned legal experts and the public, well, as far as they even are aware, Mark Rutte's legal team, in coordination with NATO, proposed a settlement to Karim Aachboun. 3 million euros. That's right, 3 million. But it wasn't just a generous payout, it was a deal loaded with strings. Strings so tangled, so sinister, that they really demand scrutiny. As always, the devil is in the details. This wasn't just money, it came with conditions so outrageous, the sum itself seemed almost irrelevant. First, Karim Aachboun would have to drop all ongoing legal actions. Not just against Rutte, but also against NATO. Second, and most interestingly, he would be required to remain completely silent about the Demmink case, a politically explosive issue involving allegations against the former Dutch Ministry of Justice official. I will come back to this case in a moment. And finally, Aachboun would have to emigrate to a country outside of the European Union. Can you imagine? Let's unpack this. 3 million euros sounds like a lot of money. But at what cost? The silence on the Demmink case, a matter completely unrelated to NATO, raises serious questions. Why would Rutte's legal team, or NATO for that matter, be so invested in burying this issue? Critics argue this condition reflects a broader attempt to suppress scrutiny and protect powerful figures from uncomfortable truth. Sounds almost like a cliché. Again, more on this in a moment. And then there is the emigration clause. Forcing Aachboun to leave the European Union isn't just extreme. In legal terms, it's just mind-blowing. It sends a clear message. If you challenge power, you will be erased from the narrative. You will be removed from the stage entirely. This isn't just about silencing him. It's about making him completely disappear. And what was Karim's response? A firm, unequivocal no. Money can't buy justice, he said. I won't trade my integrity or the rights of those I represent for financial gain. His rejection of the settlement wasn't just about principle. It was a stand against the systematic abuse of power. Let's think about what this offer represents. It's not just an attempt to resolve a legal dispute. It's a concerted effort to rewrite the whole narrative and to sideline the man who dared to hold truth to power. By rejecting the offer, Karim is sending a powerful message. Justice is not for sale, at least not by him. And isn't this exactly what this case is about? Whether our systems of government prioritizes truth and accountability, or whether they can be bought and silenced with a hefty check. And now, as promised, we turn to one of the most controversial elements of this saga, the Demmink case. It's a topic long swept under the rug of Dutch politics, despite years of allegations, investigations and some public outrage. But here's the interesting part. The Demmink case has absolutely nothing to do with NATO. It has nothing to do with Karim's case. Yet somehow it made its way into the settlement conditions. So what is the Demmink case? Joris Demmink, the former Secretary General of the Dutch Ministry of Justice and Security, has faced allegations of sexual abuse involving minors as young as 12. These accusations date back to incidents in the Netherlands and Turkey in the 1990s. Despite multiple investigations, no charges have ever been filed against him. Critics allege a systematic cover-up, a deliberate effort to protect him. A claim that has only fueled public anger and deepened suspicion. But why does this matter now? Because Karim's proposed settlement included a condition forcing his silence on Demmink, a case completely unrelated to his fight against Rutte. So why include it? Why demand that Karim never speaks of the Demmink case when his case has nothing to do with these allegations? The answer, many believe, lies in what the Demmink case represents. A lingering shadow over Dutch politics, a symbol of how power is used to suppress inconvenient truth. And again, here we have the cliché. By tying Karim's silence on the Demmink case to the settlement, it raises a chilling question. Who exactly is being protected? Is it really just about shielding a former official? Or is it about safeguarding an entire system, one where accountability is a privilege, not a standard? Let's be clear, including the Demmink case in this settlement wasn't an accident. It was calculated. It was a message. And the message is clear. Some topics are too dangerous, too politically sensitive to be aired in public. This is probably also the reason why you hear nothing of all of this in the mainstream media. For Karim, or anyone else for that matter, to even mention the Demmink case would mean reigniting a scandal that those in power want to stay buried, and buried deep. This clause wasn't about resolving a legal issue. It was about erasing a whole narrative, about silencing one man to protect a vast web of influence. So ask yourself this: what kind of democracy allows truth to be suppressed just to shield the powerful? And the elephant in the room, the media. So let's talk about something just as revealing as the case itself, the public reaction, and more importantly, the media coverage, or better, the lack of it. For a case this massive, involving figures as prominent as Mark Rutte and institutions as powerful as NATO, you'd expect headlines plastered across every major outlet. But instead, silence. A silence so deliberate, so coordinated, it practically screams for attention. The media silence is deafening. In the Netherlands, coverage has been sparse at best, often buried under lesser stories. And internationally, barely a whisper. It's as if the story has been deliberately muted, suffocated under its own weight. But why? And by whom? Why would the so-called free media, the fourth estate, shy away from a case that challenges the very foundations of justice and power? Let's not be naive. Media silence isn't accidental. It's strategic. When a story like this is ignored, you have to ask, who benefits? Is it NATO eager to protect its reputation? Is it the Dutch political elite shielding one of their own? Or is it the broader web of power that knows scrutiny here could lead to scrutiny everywhere? But the lack of courage does more than just suppress the story. It warps public perception. Public opinion is shaped by what people see, hear and read. When a case like this is swept under the rug, it creates a vacuum. And in that vacuum, misinformation thrives. People begin to doubt the legitimacy of the case, not because it lacks merit, but because they have been conditioned to believe that if it were important, it would be everywhere. And here's the irony. The very act of silencing this story only makes it louder for those paying attention. Activists, independent journalists and social media users have stepped into the void. They are amplifying the story in ways traditional media refuses to. Hashtags are trending, grassroots campaigns are growing, and the pressure is building. But it shouldn't have to be this way. The media's job is to inform, to hold power accountable, not to serve as its accomplice. So what does all of this tell us about the state of our media landscape? It tells us that stories challenging the status quo face an uphill battle, not just in court, but in the court of public opinion. And it tells us that when institutions close ranks, when governments, media and powerful figures align, it is the truth itself that becomes the first casualty. Let's step back for a moment and look at the bigger picture. What does this case really tell us about NATO and the legal framework that protects it? NATO's immunity, enshrined in international agreements, was designed to ensure its operations remain unhindered by local legal systems. But here's the question no one wants to ask. What happens when that immunity is used not to protect the mission, but to shield individuals from accountability? If this case sets a precedent that NATO's immunity can supersede human rights, it sends a dangerous message. It tells the world that international organizations operate in a realm above the law. Imagine the implications, not just for NATO, but for any institution with similar legal protection. The United Nations, the International Monetary Fund, the World Bank, all of them rely on immunity frameworks. Are we prepared to accept a world where human rights are subordinated to bureaucratic shields? And this isn't just hypothetical. If Karim loses, it could embolden other institutions to double down on their immunity claims, knowing they're absolutely untouchable. Other victims of systematic injustice, whether in war zones, financial collapse or humanitarian crisis, will find it even harder to hold those organizations accountable. So this isn't just a theoretical debate. It's about real people, real lives. But let's not forget what would happen in the unlikely case that Karim wins. That victory would be seismic. It would prove that no organization, no matter how powerful, is above the principles of justice. It would open the door for others to challenge immunity, not to weaken these organizations, but to ensure they operate with integrity. Because isn't that the point? If NATO or any other body claim to stand for human rights and justice, shouldn't they be held to the same standards? And then there is the broader issue of diplomatic immunity. Originally conceived to protect diplomats and officials from politically motivated lawsuits, it has become a tool to insulate power from scrutiny. In cases like this, it's no longer about protecting a mission, it's about shielding the powerful. So we need to ask ourselves, has immunity outlived its purpose? Or can it be redefined to balance protection and accountability? What makes this case so remarkable is its potential to ignite a debate on a global scale. So this isn't just about Rutte. It isn't just about NATO. It isn't even about Karim. It's about every victim of systematic injustice who has ever been told that the people or institutions responsible are untouchable. A victory here could start a domino effect, challenging legal frameworks that have gone unquestioned for decades. And here's the reality. This case is already being watched by legal experts, human rights advocates and political leaders worldwide. What happens in Brussels won't stay in Brussels. It will set the tone for how we approach justice in an increasingly interconnected world. A world where power serves the people, not the other way around. A world where justice is universal, not selective. So where does this leave us? As we await today's court ruling on February the 3rd, it's impossible not to reflect on the key issues this case has unearthed. At its core, this is a battle between power and accountability, between immunity and justice. It's about whether institutions like NATO can continue to operate without facing the scrutiny of justice. And the stakes couldn't be higher. If the court sides with NATO and Rutte, it could set a precedent that immunity supersedes all other considerations. For victims of systematic injustice, it would mean yet another door closed, another avenue of accountability blocked. But should the court rule in favor of Karim Aachboun, it would be nothing short of a legal earthquake. It would crack open the armor of immunity and send a powerful message. No institution, no matter how influential, is above the law. And yet Karim Aachboun is under no illusion. He knows that win or lose today, this battle is far from over. The implications of this case will echo far beyond this courtroom. And that's why Karim is preparing for a prolonged fight, turning to the public for support. He has launched a crowdfunding campaign aiming to raise 1.4 million euros to cover his mounting legal expenses. I've added a link in the description. So as we count down the last minutes to today's court ruling in Brussels, let's remember what's at stake. This isn't just about one man or one case. It's about the kind of world we want to live in. A world where power is held accountable, where justice isn't for sale. Where the voices of many can challenge the silence of a few. Whatever the outcome today, one thing is certain. Karim Aachboun's fight reminds us that pursuit of justice is never in vain. One last thing. Critical voices like the ones you hear on this channel are being actively silenced and suppressed. You may not notice it, you may not know it, you may not even believe it, but it does happen. And I have the statistics to prove it. So if you do value sharp, unfiltered analysis that doesn't follow the mainstream narrative, hit subscribe, like and share. It really makes a difference. And for those who want to keep up with my work, make sure to join me on Substack. No restricting algorithmic filters there. Or listen to my podcasts on Apple Podcasts, Spotify or Amazon. The links are in the description below. Thank you.